find something in the news, that they will pursue it. I mean, they testified to that fact yesterday, that that is something that they do. So I think.
Okay, great. Thank you. Thank you so much.
Thank you. Would you call the next witness, please?
I do see their point that the
Christopher Savoie.
Thank you very much.
Good afternoon. You state your name and where you're from for the record, and we are interested in hearing about your experience with the Court of Judiciary.
Yes, sir. Thank you, Mr. Chairman. My name is Christopher Savoie. I am from Franklin, Tennessee. I'd like to thank you, the Court of the Judiciary, for listening to these stories today, and thank you, honorable senators, for trying to understand the problems that litigants can have with insufficiently trained judges, how their lack of due care sometimes wreaks havoc on the lives of so many people, often irreparably. I think this was kind of a good segue because I don't know how much I really need to get into my particular story because I have been on the news, unfortunately. Believe me, I would rather not be in this room telling you about the kidnapping of my children, Isaac and Rebecca. Isaac's birthday is this Saturday, and instead of being here, I should be at Publix picking out his birthday cake and going to Toys R Us with him to pick out a birthday present. On the morning of March 30th, 2009, my children's passports were safely locked up at the courthouse, and Judge Bivens in Williamson County had granted a temporary restraining order which barred my children from traveling internationally with my ex-wife. Her irrational and contemptuous behavior fueled my concerns that she intended to abscond with my children to Japan. And today I stand here before you as a grieving father. Again, I said my son's birthday is this coming Saturday. I'll not even be able to speak to him on his birthday, give him a hug, or watch him blow out candles, all because a biased judge wished to believe his recollection of quote-unquote confidential mediation sessions mandated by this legislature, and believe those private caucus recollections rather than the written and other evidence in front of him. Without the passports that this judge, and I will, under consideration of your request, leave him unnamed, gave to her, she would not have been able to perpetrate this crime. In order to make this decision, this judge violated Supreme Court rules and even statutes passed by this very legislature that were designed to prevent such conduct. So we're not talking about something that's within the rules of discretion. We're talking about actual statutes that were violated, violations of Supreme Court rules, which would fall into an ethical consideration of this. And it's all been on the news. I want to, if you can grant me the leave to just divert a little bit to something like Mr. Hooker's top-down viewpoint of things, because I think I can at least point out to some of the root of where I think the problem is and why we're struggling with this, how to have oversight and how to allow judicial proceedings to continue to conduct themselves in a timely, efficient, and manner that will give justice. I'm sure many of you have read The Social Contract, and this is basically an 18th century longer version of the Caesar version of a more simplified philosophy, which is bread and circus. And here's how it works. As long as the people are reasonably satisfied that judges and those in power in society are taking care of their needs, that they are just and merciful with their subjects, there will be peace within a society. But without a venting mechanism for injustice, or when government can no longer fulfill its end of the bargain, there will be chaos and revolution. Our nation's Supreme Court created a problem in this balance between authority and responsibility with its landmark Stump decision, which upheld the principles of judicial immunity from civil damages. In this much maligned ruling, except perhaps by the judges themselves, the Supreme Court of this country has expanded judicial immunity in this country to include immunity for acts that are, quote, in excess of one's jurisdiction, and even acts that are, quote unquote, malicious or corrupt in intent. The idea behind this is that a fearlessness in decision-making is critical to the judicial process itself. To be sure, no legislature in our land has ever knowingly conferred this immunity on judges or any protected class of people. The judges gave this privilege to themselves. And like frogs in slowly boiling water, we have learned to accept this notion that judges are immune from civil monetary remedy, without questioning the origins or wisdom of this concept, or its expansion under Stump, despite the scathing dissension that the decision received from Justice Brennan. Let there be no doubt that the simplest way to rid us of this problem and all the problems that we've heard today would be to reinstate civil penalties for judges who are negligent or grossly negligent in their conduct, just like heart surgeons, lawyers, truck drivers, and policemen. That's what Section 1983 intended to do. And it still doesn't preclude civil remedies against lawyers, but the Supreme Court of the United States has said that that is the case, that they will be saved from civil damages. But if we're not willing to do this because we believe that the judicial immunity is a God-given right under the principle that all men are created equal, then so be it. We need an alternative solution. Our great state of Tennessee, in a wise understanding of the social contract principles, has realized that without an effective court of the judiciary, we now run the risk of judges violating statutes, committing unethical and malicious acts without any civil consequence. Without the risk of facing any civil penalties like the rest of us do, without alternative remedies to meet justice against judicial wrongdoers, we open ourselves to the possibility of grave and intentional miscarriages of justice. Honorable members of our legislature and judiciary, this honestly undermines the social contract, which is the underlying basis of any government or judiciary's authority. Without effective remedy, without effective justice against those who abuse their authority, our ability to protect justice in our land is stymied. And without proper prosecution and effective punishments, there can be no remedy, and there can be no balance between authority and responsibility. So what about my case? Why am I here? Why is my complaint with the court, where is my complaint with the Court of the Judiciary? Well, my case has been all over the news. Many of you know that I was at the nation's capital last week supporting a House resolution about my case and other similar cases, which I drafted. A resolution that was passed by a vote of 416 to 1. My federal case against the people I feel are responsible for my damages is well known and highly publicized. I'm a law student, and all of my professors and my staff know about my case, and the staff at the school. There's an overwhelming consensus in the public eye that the judge, in my case, acted unethically at best in taking my case and in the way in which he adjudicated it. The transcripts and the federal complaint are all available online. News organizations have had no problem getting access to these documents. I'm here today because I need to ask the Court of the Judiciary, what, if anything, has the Court of the Judiciary done to investigate any possible accusations of wrongdoing in one of the most high-profile cases of a Tennessee judge possibly behaving incorrectly and possibly unethically? We're still waiting to find out. All I know is that nobody has, until this very day, asked me for my testimony about what occurred in this state. Is the onus on me as a victim to ask the court to do its job? Or is the Court of the Judiciary motivated to seek out these abuses and prosecute them to the full extent of their authority? Why is the man who mistakenly gave permission to a kidnapper to take children out of this country still sitting on a bench that decides custody cases? Has there been a definitive ruling saying that his behavior was indeed ethical and legal? That I might understand. Or, as I suspect, has no one even bothered looking into this? And believe me, one does not need to look very far to find out about my case. I've put some facts in front of you about that. I don't intend to rehash any of the particulars about that, but we're talking about violations of Supreme Court Rule 31 that says you may not be a mediator and then become a judge because you're subject to testimony given not under oath in private caucus with the other party.
You mean in the same case?
In the same case.
Right. Judge, someone shouldn't mediate a case and then
become the judge in that case later on.
Obviously they would need to recuse themselves.
They didn't.
And I may be the only person in this room that's not familiar with your case, but I have no idea what your case. I mean, I'm
okay.
Perhaps,
Let me just give you a summary, though.
This is not the venue for
Sure.
us to do it, but I'm just saying to you,
Mm-hmm.
I am very interested in your dealings with the court of judiciary, though? Because it sounds like whatever your experiences are very traumatic, and it sounds like they've been in the media, and it's my understanding court of judiciary, if they see something that they believe violates the things over which they have jurisdiction, that they will seek out a petition, and perhaps that'll be done more with full-time disciplinary counsel now, as opposed to a part-time.
Well, that is the problem.
Position.
Excuse me, Mr. Chairman. Yes, I agree, and that's why this was a beautiful segue, because this one is the most high-profile case of someone doing something that says very specifically in the statutes that they're not supposed to do. And it's all over the national and international media. They know about it. My law school professors know about it. And, we can make a connection between the two of them. One of them happens to be the chairman of the Court of the Judiciary. Okay? So it's known about, but no action is being proactively taken on the part of the Court of the Judiciary to do anything about it. If they're waiting for a complaint from me, I'll tell you why it's not coming, because one of my attorneys right there will tell you why. Just a week ago, she appeared in my federal case, and right after that, a case that was being heard in front of this same judge was being heard. Okay? When she appeared in this case, he immediately recused himself halfway through those proceedings as a retaliation for her appearing in the case, which I am seeking redress for my damages. Okay?